issues, which is 100, shall also be the percentage such beneficiary shall be entitled to for the trust assets which remain in the termination of the trust. Meaning that if you hold 50 units, that means that you own 50% of the assets in the trust. Section 4. No beneficiary may hold title to any of the trust assets and shall have no vested interest in any trust income until the actual termination of the trust or its early distribution. Neither the income nor principal of the trust shall be liable for any personal debt of the beneficiary. Section 5. No beneficiary shall have any management power over the trust. Section 6. No TCU holder, quote unquote beneficiary, shall have any power to sell, assign, transfer any of his or her units except under the procedures as set forth by the bylaws. Article 11, Transfer of Trust Certificate Units. Section 1. In accordance with the state purpose of this trust, the transfer of TCUs is strictly limited. So a TCU holder may transfer, sell, exchange, or give their units to any other persons only if the transfer is approved by a unanimous vote by the trustee or the board of trustees or the board of directors. Okay, so a new certificate will be issued to the new TCU holder, and approval of the legitimate request for a transfer shall not be unreasonably withheld. Okay, so if you are a TCU holder and you want to transfer it to your child and you not be an active beneficiary, you can do that. Section 2. Any determination of the board regarding the approval of the transfer shall be final. Section 3. The death of the TCU holder terminates his or her interest in any rights of the trust estate. Section 4. Any holder may request that the board of trustees or directors accept a named successor holder that will receive the original holder's TCU and their associated rights upon his or her death, which means that you can actually appoint your child or children as successor TCU holders before you even pass away. Section 5. In no such transfer was approved and recorded in the minutes, then the TCU will be transferred on a prorated basis among the remaining TCU holders. Article 12, Distribution of Income and Assets. Section 1. It is determined by the Board of Directors or Trustees that there is income distributable to the holders of the Trust Certificate Unit TCUs, and that income is taxable to those beneficiaries, okay? And as well to the trust. Whatever the board shall distribute a sufficient amount of such income to prevent such income from being taxable to the trust, okay? Section 2. If after the distribution to the beneficiaries, there is actually income that remains, then that income is actually going to be considered principal and allocated to trust assets. Okay? Section 3. The Board of Directors shall make an annual determination of the existence of distributable income. Section 4. Income shall be distributed only in the same ratio of numbers of TCU held by each holder, which means that if you hold 50 TCUs, that means you have 50% of the allocated assets of the trust, which means that if there's income that needs to be distributed, let's just say that income is $100,000, you're going to get $50,000 of that $100,000 because you hold 50 units, which is equivalent to 50%. Section 5. Any TCU holders may apply to be a board of directors or board of trustees or a trustee for the advancement towards the future distribution of both income and principal. So the board may consider such application based upon emergency circumstances relating to health, education, maintenance of any holder of the TCU. Any decision of the board to distribute or not distribute any of these dollar amounts shall be final. Section 6. The board, in its discretion, may at any time distribute to any holder an amount which the board determines to be consistent with the purpose and intent of the trust. Section 7. Any distributed income shall be charged to the amount of the holder receiving the distribution and deducted from any future distribution incomes. So if there is not enough future income, then that will be covered in the distribution, and the balance of the advancement shall be deducted from their trust assets. Section 8. The board may at its discretion make an annual gift not to exceed $10,000 to each TCU holder. Article 13. Renewal of the trust. Section 1. The board of directors or trustees shall have the power to renew the trust for any reasonable term not to exceed the original term, if it is determined that the board to be in the best interest of the beneficiaries and are no obligations, then the decision to renew the trust shall be made between 60 days and 120 days before the original termination date. Any further renewals shall be handled the same way as the first renewal. So typically for your business trust is 25 years. And if you wanted to renew it, then you would have to do that 60 days before the 25-year mark is up, and you could renew it for however long you want it. So if you wanted to renew it for 10 years, 15, or additional 25, you can. The same thing goes for your family trust. Typically, it runs for 100 years. So at that 100-year mark, 60 days before, you can renew the family trust, and you can renew it for an additional 100 years. Section 2. If any beneficiary objects to the renewal, the board shall distribute to that beneficiary such portions of the trust asset as he would be entitled in the event that the trust terminated or continued the trust with the remaining trust assets and beneficiaries. The TCU held by the objecting beneficiary shall be turned into the trust and shall be redistributed to the remaining beneficiaries in equal portions. Such distribution shall be noted in the minutes of the trust. So this means that, let's say that there's 4 beneficiaries and every beneficiary owns 25%. And it's time to renew the trust for another 100 years. But one of the beneficiaries disagrees because they want their portion. They are tired of getting just quarterly distributions. Then what's going to happen is they are going to distribute the assets that pertain to that 25%. So let's just say, for example, there's 100 homes in the trust assets. They're going to distribute 25 of those homes, and they're going to deed it over to that one beneficiary that owns 25% or 25 TCUs. Okay? And now what they're going to do is they're going to take those TCUs back. They're going to take those 25 TCUs. They're going to distribute those 25 homes to that beneficiary, and now that beneficiary is removed from the trust, so they can no longer benefit from the trust anymore. Now the trust goes down to 3 beneficiaries, and those 25 TCUs need to be redistributed to the 3 beneficiaries. So now instead of them owning 25% each, now they're going to get more TCUs, which is probably going to put them in a position to owning 33.3% of the trust assets, which will hold them at TCUs of 33.3 TCUs. Article 14, privacy rights and non-disclosures. Section 1, no officer of this trust shall disclose to anyone any information pertaining to the trust certificate unit holders. The grantor has stated that no one will disclose the identities of any and all TCU holders. Section 2, to ensure the rights to privacy, no non-officers of the trust shall be permitted to view any documents of the trust except for the declaration of trust and the trust indenture sections of the original trust formation agreement, which clearly means do not show anyone your trust agreement or document. It's nobody's business but your own business. And if someone from a financial institution, a bank, a college, anything like that wants to see your trust, tell them respectfully no, that they are not allowed to see the contents within your trust, and you can only show them the declaration of trust, which proves that you actually have a trust. Article 15, amendments to the trust contract. Section 1, the board of directors or trustee shall have the power to amend or modify the trust indentures and bylaws to better carry out the purpose of the trust or in order to conform with and comply with any law, rules, regulations, or orders of any government bodies, provided, however, that any such amendments may not be inconsistent with the original trust purpose or intent, and to avoid any type of violation of the fiduciary obligations for the trust certificate unit holders. Okay? Section 2, the trustee must vote unanimously for any such amendments to pass and take effect. So the board of directors or trustees must vote unanimously, or it can be a single decision from the trustee. Article 16, acceptance of the trust bylaw. In witness whereof the grantor hereof of the first trustee, in witness whereof the grantor hereof and the first trustee hereof, in the name of the board, have hereunto set their hands and seal in token of the acceptance of the covenant, abiding all conditions herein imposed and expressed on this date. The grantor needs to sign. Next, the first trustee, which is yourself, by signing this indenture, hereby accepts on behalf of the board the properties given by the grantor and accept the bylaws, conditions, terms, provisions of this indenture and the bylaws and the resolutions of the board of directors or trustees, which shall serve as the governing instruments of the trust, agree to transfer all beneficial interests to the trust certificate unit holders or beneficiaries in accordance with the settlor's direction or grantor's direction. So the first trustee, which is you, will then be able to sign. Then this document needs to be notarized. So you have a notary section right here. So it needs to be date, notarized, and then the bylaws and the trust will be legalized at that point in time. This is the end of the module.